the spring of 2021 in order to explore various themes related to the field of transitional justice as it relates to the current efforts in the United States to redress racial injustice and violence. Our collective aim is to help raise national attention to this very important justice movement while offering a critical lens to help inform our audience about this work. So today's panel is entitled, "How can the U.S. build a transitional justice process that reckons with corporate complicity in and perpetuation of racial injustice and violence?" Today's speakers will explore the role of businesses, what role businesses must play in truth reparation and justice processes in the U.S., including strategies to hold corporations accountable. They will offer specific examples of how prison labor of Brown and Black people amounts to a form of forced labor and even modern day slavery, and how it benefits corporations. Importantly, this panel seeks to understand this contemporary exploitation within a historical context to better understand how it has been enabled through a legacy of slavery and other historical episodes of private gain through racial exploitation. As with other panels, the discussion will seek to understand this framing through a comparative approach to explore examples of other countries that sought to hold economic actors accountable for their role in violating human rights as a part of a transitional justice process. Before we start, I want to thank the co-organizers of this event, in particular, Professor Erica George, Director of the Tanner Humanities Center at Utah University's College of Humanities and a Professor of Law at the University of Utah S.J. Kinney College of Law, as well as Avery Kelly and Reynolds Taylors, who are staff attorneys with Corporate Accountability Lab. Avery will be moderating today's panel. And finally, I, of course, want to acknowledge the support of all the co-sponsors of this series who helped to make it an inclusive and far-reaching conversation. So before we get started, I wanted to give some quick instructions regarding the format of the panel. During the discussion, the chat will be disabled, but you can post questions in the Q&A. We will then start the chat once the panelists conclude to open up to a larger discussion that will hopefully include many of you. Also, the full biographies of all the participants can be found on the Speakers Series website, which is listed here at the bottom of the screen. So to begin, it's my pleasure to introduce our moderator for today's panel. Avery Kelly, who I mentioned is a staff attorney at Corporate Accountability Lab, has worked closely with affected communities and social justice lawyers to seek justice for human rights abuses committed by multinational companies. In particular, throughout 2021, she co-led the Corporate Liability and Sustainable Peace Lab, CLASP, a social lab convened by CAL, the African Coalition for Corporate Accountability de Justicia, and the Commission Interclesial de Justicia y Paz, to develop new models for corporate accountability in post-conflict and transitional justice settings around the world. Importantly, she continues to work on projects related to restorative justice work with economic actors in Colombia's transitional justice context. Thank you so much, Avery, for facilitating today's conversation, and I'll turn it over to you.
Thank you so much, Lisa. I'm so excited to be here. I've really been looking forward to this conversation. Again, I'm Avery Kelly. I'm a staff attorney at Corporate Accountability Lab, or CAL. At CAL, we focus on human rights abuses committed by companies around the world, and we seek justice and accountability for those abuses, no matter where those companies are based and no matter where those abuses occur, which can be more complicated than we would like it to be. I want to really welcome everyone to this unique discussion today that focuses on several seemingly disparate concepts, all related to social justice, but I think are often talked about in different spaces with different frameworks. So I'm really excited to see these topics being pulled together. So the way I see it, we're talking about at least three different sort of concepts here today. We're talking about transitional justice, which is really an international concept that refers to processes and systems for societies to reckon with past atrocities that have occurred. Really an international concept. We're also looking at the racist context of the United States. So we're looking at historical and ongoing violence, systemic discrimination against Black and Indigenous people of color, particularly African Americans, And we're looking at that with a particular lens on highlighting mass incarceration and the exploitative prison labor system that we see today. We're also looking at these local calls for racial reckoning that Lisa mentioned that have arisen in the last few years, really in municipalities around the United States. All while we're talking about these different sort of themes, we're also looking at the role of the private sector and in those abuses and thinking about what corporate accountability actually might mean given the role of the private sector, not just individual actors, not just state actors in the past. See, I'm getting a note in the chat. You can hide non-video participants. Okay. So we're talking about this, all of these different things, thinking about the private sector role and what corporate accountability might look like. Also looking at these different frameworks for analysis. And I think levels of analysis as well. As I mentioned, we're thinking about local initiatives for racial reckoning. We're talking about our national history in the United States and national mass incarceration and prison labor systems. And then we're talking about international concepts and transitional justice. So I want to give the disclaimer that we're not going to cover everything in depth today. But I do think we're going to try to connect some of these seemingly disparate concepts in a way that's helpful. And I think we really want to use this analysis to push forward conversations about racial justice in the US, obviously the role of the private sector in facilitating and benefiting from abuses historically and to date, and what the US can learn from transitional justice processes around the world, and perhaps how those processes might inform processes for racial reckoning here in the States. So I thought to get us started, I would just give my own 2 cents about some of these concepts, share some relevant work that Corporate Accountability Lab has done in these spaces, and then I'm going to invite the panelists to weigh in on some of these thoughts that I'm sharing and to correct me or add some nuance in your own remarks. So I thought I'd start with a little bit on transitional justice, which really my thinking here is from my experience with Corporate Accountability Lab. Lisa mentioned that my colleagues and I, including the panelist Tatiana Devia, and I have been part of a social lab where we're pulling in folks from around the world working in different contexts of post-conflict and transitional societies, looking at corporate accountability. And when we think of transitional justice just as a whole, I think it really becomes relevant in countries where mass atrocities, dictatorship, armed conflict, genocide have taken place. And there's generally a moment where there's a formal end to the conflict. A dictator has been ousted or a peace accord is agreed upon. And there's an intentional decision at that time within societies, countries who have gone through these atrocities to implement processes to reckon with the past. And this really looks different in different contexts. This is transitional justice, as we've seen some very prominent examples. For example, the Nuremberg trials in Germany after the Holocaust. We can think about the truth commissions in Argentina and Chile after the dictatorships of the 70s and 80s, processes in Rwanda and South Africa, and today's most advanced transitional justice system that's ongoing in Colombia. These processes of transitional justice are often formal. They include truth commissions and judicial tribunals, massive institutional reforms, all generally focused around 4 pillars, what are seen as pillars of transitional justice, which are truth, justice, reparation, and guarantees of non-repetition. Generally, the historically what we've seen is that although there's most certainly abuses committed by the private sector, including multinational corporations, in situations of armed conflict, situations that are the basis for which transitional justice often occurs, we don't see a focus on corporate accountability in those processes themselves, although the role, again, is certainly there. And we think that this undermines sustainable peace and as a gap for those 4 pillars, again, that I mentioned that transitional justice aims to address. But as I mentioned, folks at Cal and others that we've been working with, the African Coalition for Corporate Accountability and our partners, de Justicia and the Comisión Intereclesial de Justicia y Paz in Colombia, have been working towards really sharing innovation, what's happening around in different spaces in the world for holding companies accountable in transitional justice. So we're holding that concept in one part of our brains, where we're also thinking about the national context in the United States, looking at this racist history in which our economy and much of our infrastructure was built by enslaved Africans for public and private gain. A country that I think has really squandered opportunities from transitional justice, not just currently with this administration, but historically, when we look at the Emancipation Proclamation, the end of the Civil War, when we look at failed promises for reparation, including the 40 acres and a mule famous promise, all the way to today. And that brings us to questions about what does it mean to have had slavery never actually fully abolished, with the exception that's written into the 13th Amendment, to today where we have mass criminalization of Black and Indigenous and people of color, particularly African Americans, mass incarceration, and then exploitative prison labor programs. And it's not lost on me the gravity of the situation, that how exploitative these programs are. In fact, recently Cal published a report that applies the International Labor Organization's indicators of forced labor to the US prison system and finds that there is forced labor occurring today in the US prison system. So connecting those concepts, again, with the focus of local initiatives that are popping up across the states and have for the last few years, movements for racial reckoning that have so much potential, there's so much appetite to do something, but that are also piecemeal and don't look like transitional justice processes in other countries. And they're often not connected to the learnings from those transitional justice processes. For one, they tend to not look at corporate actors. So those are just some of my 2 cents on how I'm thinking about some of these concepts. And I think I'll speak for myself that I tend to get really focused on the history and the nuances of the context. And then I can kind of leave in a space of, well, that's what it is and not sure where to go forward. So I'm going to encourage myself as the panelist to think about not just drawing out the context and the history, but okay, what does this mean? And what does it mean going forward with all of these, all this context in place? So as I and my colleagues at Cal continue to grapple with these issues and how they connect, I'm so glad that we can discuss them with you all today and learn from the incredible panelists that we have joining us. So joining us for today's conversation, we have Lydia Wright, who's the Associate Director of Civil Litigation at the Promise Institute of Justice Initiative. She's going to give us some historical context on the history of slavery and prison labor in the United States. Then we're going to turn to Anita Sinha, who is a professor of law at the American University Washington College of Law, where she directs the International Human Rights Law Clinic. She's going to speak to us about forced labor at immigrant detention centers in the States and efforts around corporate accountability there. Then we're going to hear from Daniel Rosen, who's a campaign manager at Worth Rises, who is also bringing his perspective as having been formerly incarcerated. He's going to discuss the prison labor system in the United States, including forced labor and the End the Exception campaign. Really excited to have Daniel with us today. And finally, we'll hear from my colleague at Corporate Accountability Lab, Tatiana Devia, who has a wealth of knowledge on transitional justice systems and efforts to hold economic actors, as they're called in the transitional justice space, accountable in post-conflict settings. So she's going to share with us some lessons learned from around the world that may apply to the US context. So I'm so excited to have this conversation with all of our distinguished guests today, but we do want to note at the outset that this panel of experts does not include voices of African Americans. This is something that we certainly welcome if folks want to weigh in the chat or pose questions. The speaker series does aim to include African American voices in every panel, and we just want to note that that voice will not be heard from the panelists here. So with that, I'm going to turn over the mic to Lydia Wright to kick us off with some historical context. Lydia.
Thank you, and good afternoon, everyone, and thank you so much for inviting me to be here today. It's a real honor. I am the Associate Director of Civil Litigation for the Promise of Justice Initiative, based out of New Orleans. We're a nonprofit organization that works to change the criminal justice system through impact litigation, organizing, policy advocacy, and community engagement. And we are deeply engaged in efforts to end forced labor in prisons and jails in Louisiana. And in doing this work, we're guided by 4 basic principles that I just want to acknowledge at the outset. We think that work should be voluntary, it should be safe, Workers should be appropriately compensated for their labor, and work should contribute to a person's success in the future. Today, I'm going to speak a little bit about plantation prisons in the Deep South, particularly in Louisiana, where, notwithstanding the 13th Amendment, slavery has not actually ended. The Louisiana State Penitentiary sits on the grounds of a former slave plantation. It was and remains today known as Angola, reportedly because the best slaves came from that African country. Today, Angola is the largest maximum security prison in the United States, and it's an 18,000-acre penal plantation. It's larger than the island of Manhattan. Roughly 4,000 people are incarcerated there right now. Most are Black men who are serving sentences at hard labor. Through our class action impact litigation, PJI represents every adult who is incarcerated at Angola. And nearly every one of those people at some point has been or will be forced to work in the fields. This is called the farm line. This work is grueling and it's dangerous. On the farm line, men are forced to walk into the fields, sometimes for miles, carrying blades or shovels or hoes. They are forced to handpick okra or cabbages or pecans or dig ditches. They're overseen by armed guards on horseback, who are known as freemen. They work in extreme heat and humidity, particularly in the Louisiana summers, without basic safety gear or modern agricultural equipment, even though the prison has it. And it's often so hot and humid on the farm line that people pass out or suffer heat stroke. Our clients have even witnessed the officers' horses passing out from the heat in the summer. The health and safety risks inherent to this work are particularly acute for folks with disabilities who should be excused from field work but are not. And if folks refuse to work or if they fail to meet a productivity quota, they're further punished, including by solitary confinement or loss of phone time or canteen privileges, or they're assigned extra shifts on the farm line. During their first 3 years of incarceration, these workers receive no money at all for their labor. During this period, they are paying back the prison for their prison-issued uniform. And after that, they can earn up to 2 cents an hour. For context, 1 minute of phone time at Angola costs $1.10. That's 55 hours of work. 1 roll of toilet paper from Canteen costs $1.13. That's about 56 hours of work. A visit to the doctor costs a copay of $3 or 150 hours of work. And an emergency sick call, so if you pass out in the field and you need an EMT, that's $6 or 300 hours of work. This work serves no penological or institutional purpose. It's not rehabilitative, it's not vocational. Most folks at Angola come from cities and they have no intention of being farmers when they leave. So what is the purpose of forced agricultural labor at Angola? It's to punish and to profit, and it's always been that way. Penal plantations are not a modern invention. They arose in the aftermath of the Civil War as a means to retain slavery as an institution. The use of convict labor began well before that. Louisiana built its first state penitentiary in 1837, and the state quickly realized how expensive it is to run a prison. So to save money, later to make money, the state began leasing prison operations out to private contractors. And it was hugely profitable for the contractors, who could then send the prisoners out to work on farms or railroads or levees, and they could maximize profits by reducing expenditures on basic necessities. Conditions during this pre-Civil War time were so stark, prison conditions were so stark that one state legislator complained that although most convicts were white, they were being treated like slaves. After the Civil War, the demographics of Louisiana's prison population changed dramatically when half the state's population became citizens. And the 13th Amendment, of course, was ratified in 1865 and abolished slavery except as punishment for a crime. And this penal exception to the 13th Amendment allowed the state to use incarcerated labor as a means of replacing the free labor force that had been supplied by chattel slavery. To do this, the state enacted a series of discriminatory laws known as the Black Codes. These laws applied only to Black folks and subjected them to criminal prosecution for what might have been a misdemeanor otherwise, offenses like loitering or not carrying proof of employment. The objective of the Black Codes, according to the Louisiana legislature, was to get things back to as near to slavery as possible. To that end, the Black Codes were effective. For the first time in US history, the Louisiana penal system held more Black prisoners than white. Shortly after the Civil War, a former Confederate major named Samuel James bought the plantation that's now known as Angola, and then bought the convict lease from the state and began working convicts in his own fields. He also leased them out to the levees and railroads. Angola became known as the James Prison Camp, and it became known as one of the most brutal and cruel places that you could be. It was also extremely profitable. In 1870, James made $500,000. And if we're talking about brutality, each year between 1894 and 1901, an estimated 10% of people incarcerated there died. Lost 10% of the population in each of those years. By 1901, 90% of all inmates in Louisiana were Black. Convict leasing was eventually prohibited in Louisiana around the turn of the century, in part because the free convict labor competed with free labor for jobs. In 1901, the state bought the Angola plantation from the James family and established the penitentiary there, but little has changed for the inmates even to today. Inmates were still housed in old slave quarters, and they just continued picking cotton for the fields that were now owned by the state. And they still do. Louisiana's corrections department has a for-profit arm called Prison Enterprises. Prison Enterprises operates the industry and the agricultural operations. They operate the farmland at Angola today. And so today, folks incarcerated at Angola build office furniture, they make mattresses, they build, they make the uniforms that they then wear. They raise cattle and agricultural crops that are then sold on the open market, sometimes by auction, through Prison Enterprises. They also operate a canteen program, which sells hygiene products and food to incarcerated people. That generates $11 million a year in income. And at the same time, only 1% of the budget for Angola is dedicated to rehabilitation programs. So for the last 175 years, the state of Louisiana has relied on incarcerated people to produce a financial profit, or at least to make the penitentiary self-sufficient, even when it was leased to private interests. And there can really be no question today that prison labor is designed to benefit primarily public entities that capitalize on a vulnerable population that is both a captive labor force and a captive consumer base. Folks have to work because if they don't, they will be punished. And if they don't work for their 2 cents an hour, they will never be able to accrue the time that they need to talk to their loved ones on the phone or to be able to afford the toothpaste from the canteen. As part of our effort to end plantation prisons in Louisiana, PJI has been documenting the experiences of our clients, of men and women who have been sentenced to hard labor at Angola and in other facilities throughout Louisiana. And those testimonials are online, and I would invite you all to visit our website. Maybe we can post it in the chat to hear about forced labor directly from the people who have experienced it. These are people who have all come home, but right now there are hundreds of men working in the field in Angola in conditions that are reminiscent of the days of chattel slavery. And that website is labor.promiseofjustice.org. And I'll put it in the chat when I have the opportunity. Thank you.
Lydia, thank you so much for sharing just that wealth of information with us and really disturbing conditions that are happening in Louisiana to this day. I wanted to ask a couple of follow-up questions before we move on to our next panelist. One, I wanted just to give you an opportunity to talk about what does PJI's representation of the folks at Angola look like? What are the things that you're representing them for? What are those claims? And then secondly, I wanted to turn to what do folks who are currently incarcerated at Angola and those who have been released and survived, what do people want? What are they looking for? What does justice look like when you have such an egregious system that's currently in place and then rooted in that history you laid out? So I'll turn it to you, Lydia, if you want to respond to either of those.
Sure. On the first point of what does our representation look like at Angola, our organization has been around for about 10 years. We cut our teeth on impact litigation, seeking to get air conditioning at death row at Angola, where temperatures can exceed 110 degrees and 100% humidity regularly. We currently represent every individual incarcerated there, every adult incarcerated there, because about 7 years ago, we sued the Department of Corrections to improve medical conditions at Angola. And so, and we certified a class on that basis. Our organization regularly litigates in federal and state courts, including the US Supreme Court, and we have won. Our focus is to improve conditions of confinement, not just at Angola, but elsewhere in Louisiana, and eventually to reduce prison populations and get folks out. As to the second question of what does justice look like, or what do our clients want, I would again refer people directly to the voices of the impacted on our website through these video testimonials. They'll tell you what they want, and not particularly comfortable suggesting that I know what somebody else wants. I can say that the 4 pillars that guide our work in this sphere were developed through years of work with these incarcerated folks and folks who have come home. I was at Angola 2 weeks ago and met with about 20 guys who are assigned to the farm line and would rather be in school or would rather be learning skills like becoming a healthcare orderly. There are folks who were welders on the outside, and yet they're forced to pick turnips with their bare hands in a field all day. So there's dignity in work, and people want and deserve it. They deserve to be compensated. They deserve to have choice in what they do. And they deserve to be treated humanely. And I will say that nearly every person currently incarcerated or formerly incarcerated from Angola that I have spoken to compares the current labor situation there to modern day slavery. That is how people feel about their situation, and that is certainly how it looks from the outside.
Thanks, Lydia. I want to ask one final question. We only have a couple moments, and this is probably bigger than time allows, but I thought you and then maybe Daniel could weigh in on this when he speaks later. But it's my understanding that last year, ending the exception to the abolishment of slavery in Louisiana was actually on the ballot, and folks voted to not get rid of that exception. Mm-hmm. And so I wanted to just get your insight on why that happened. Is it attitudes really haven't changed, or is it disenfranchisement, or is it something else? Are people not able to vote? Or do we just not know? So I'd love to get your take on that. And maybe Daniel can also weigh in when he speaks later.
Yeah, I am also excited to hear Daniel's take on this. So several states have recently attempted to amend their state constitutions to eliminate the exception for hard labor as punishment for crime. In Louisiana, that amendment failed by a popular vote by a 22-point margin in 2022. And the one reason is that it was a convoluted amendment. There were some problems with the language that made it confusing. There were some concessions made to some legislators that cause confusion on the ballot. That's one reason. Another reason is Louisiana. It's tough to, it can be really tough to make progressive change here and progressive reform here. So I will just leave it at that.
Thanks, Lydia. I'm sorry to give you just a few seconds to answer that. Looking forward to continuing that discussion throughout the panel. Now I'm really excited to turn to Professor Anita Sinha, who's going to share with us some examples of forced labor in immigrant detention centers and some efforts to hold companies accountable for those abuses. Anita?
Thank you. Thank you, everybody. Thank you, Lisa. Thank you, Avery, and the other organizers of the speaker series. I am humbled and honored to be part of this panel. I'm still reeling. I've done this work for over 20 years. And I did work in Louisiana post Hurricane Katrina, special place in my heart, and also special anger in my soul for that place, but I'm still reeling from Lydia's presentation. So I will just try to get started on mine. I was introduced to the topic of immigrant detainee labor when I was supervising a student team that was representing a detained client in my clinic. They came into my office and they were really upset that they didn't include an envelope for their client to use to respond to their mail. They explained to me that the client's response was delayed because he needed to work for a few days in order to afford the hyperinflated price of buying an envelope in the detention facility's commissary. Similar to what Lydia was mentioning, in this context, he had to work 3 days to afford $3 to buy one envelope. I reassured them that they can fix this moving forward. They could just include an envelope or more than one envelope. But I hid the fact that I actually had no idea what they were talking about. I promised myself to figure out what certainly sounded like exploitative labor in detention facilities. So I delved into some research, and in doing so, I found out that in 1950, Congress passed a law authorizing detained immigrants to work for a payment of $1 a day. It was a law that was deliberated and enacted after World War II, which is relevant for two reasons. The first was McCarthyism, right? So namely the targeting of alleged communists, including non-citizens formerly associated with the Communist Party. That targeting created a relative spike in immigration detention. So I almost cannot imagine, but not until recently, I'll get to that in a minute, until recently was immigration detention used. So back then, with the targeting of non-citizen alleged communists, it was the first time actually that immigrant detention was used by the US government at a significant scale. So we're talking about a couple of thousand a day, but for that time it was significant. And it was because, of course, accused communist non-citizens were perceived to be too dangerous to be let free pending their deportation. So putting detainees to work and paying them a nominal fee for their labor, as the Department of Justice testified in the congressional hearings in the late 1940s, early 1950s, for what would become the voluntary work program, was seen as a way to maintain order in detention facilities. So going back to this end of World War II tie, the second tie to the end of World War II in the passing of this voluntary work program was the 1949 Geneva Convention's protections for prisoners of war, right? So the Geneva Convention had a voluntary provision that the voluntary work program modeled for POW camps, and was also justified as helping to maintain order in these camps. And interestingly, it established a compensation of what was roughly equivalent to $1 a day in Swiss francs, and that was almost 75 years ago. So, as I mentioned, the voluntary work program passed in 1950. The last time the US Congress addressed the rate of pay was in the Appropriations Act of 1979, which kept it at $1 a day. That rate has never been increased or adjusted for inflation. All right, so fast forward to today. Changes in immigration law and structure have rendered immigration detention, the practice of detaining immigrants in these prison-like conditions, the largest mass incarceration movement in US history. So a few statistics to illustrate this. Between 2000 and 2016, the number of people incarcerated in federal private prisons spiked 120%. And a majority of that spike was due to the detention of non-citizens. According to the Detention Watch Network, in fiscal year 2021, the US Immigration Agency's enforcement arm, the Immigration Customs Enforcement, or ICE, had a budget of $2.8 billion. More than 70% of immigrants, this is where the private corporations tie comes in, more than 70% of immigrants are detained in facilities owned and operated by private prison corporations. So now there's about 10% in private prisons are facilitating criminal prisons and jails, but 70% are run by these private prison corporations in the immigrant detention context. So this means that the ICE uses a significant portion of its $2.8 billion budget to contract with these corporations to detain immigrants. And going back to detainee labor for $1 a day is a big part of these corporations' profit generation. As Lydia described, prison labor is nothing new, thanks to the exception clause of the 13th Amendment to the US Constitution, which, as Lydia mentioned, abolished slavery and indentured servitude except as a punishment for crime. This exception gives prisons the right to make prisoners work, like in Angola, even without pay. But a key difference from criminal incarceration is that immigration detention is not punishment for a crime. Despite its present scope and institutional design, immigration detention remains a civil regulatory scheme. The fact that immigration detention is not punishment exempts the system from many rights that are afforded in the criminal context. I'm not saying that it's, worse or better than, but immigrant detainees, for example, do not have a right to counsel. As people may know, even children who are unaccompanied don't have a right to counsel. It also raises the question, though, of whether immigrant detainee labor is a violation of the 13th Amendment's prohibition of slavery and involuntary servitude, particularly in cases when detainees allege that the work is forced. So let me now turn to the voluntary part of the voluntary work program and question whether the work is in fact voluntary. Officially, the voluntary work program is put in the category of quote unquote detainee services, right? So the voluntary work program is described by ICE as quote, giving detainees opportunities to work and earn money when confined, end of quote. This standard specifically provides that when detainees can volunteer for work assignments, they can volunteer work assignments, but they cannot be required to work except to do quote, personal housekeeping. All right, so going back to my student's client who had to work 3 days in order to pay $3 for an envelope to send to a legal correspondence to his lawyers, there is an argument at the very least that $1 a day detainee work program is coercive, right? So is it voluntary or is it coercive if a person has to buy a $3 envelope to mail to his lawyer? But more than that, according to lawsuits challenging the voluntary work program, detainee labor is not voluntary or just coercive, but actually forced, which should not come as a surprise given the role super cheap labor plays in turning profits for corporations running detention centers. So the stories that have emerged from these lawsuits are quite striking. Several involve detainees being put in solitary confinement for refusing to work or participating in workers' strikes. Another one I wanted to highlight involves a woman detained awaiting a visa for victims of human trafficking, a T visa. When she was asked for the day off her job working in the detention's kitchen, the prison staff punished her by refusing to give her sanitary pads and toothpaste. The two predominant companies who own and operate immigrant detention facilities and are getting sued for $1 a day detainee labor are Geo Group and CoreCivic. The legal claims in these lawsuits include violations of state minimum wage laws and unjust enrichment. Interestingly or ironically, lawsuits such as the one brought in Illinois claim that the voluntary work program violates the Federal and State Trafficking Victims Protection Act, TVPA, making the argument along the lines that forced labor in detention centers is equivalent to trafficking. So I want to end on a hopeful note, which is that at least two of these lawsuits, the ones in Washington State and Illinois that I mentioned that I'm following, have survived the government's motions to dismiss and are moving forward. I was really skeptical and thought they were just going to be outright dismissed, but it's been a couple of years. The corporations are fighting hard, but the lawsuits are still alive. It will be a big blow to the for-profit industry of immigrant detention if the voluntary work program is abolished or is forced to pay minimum wage. And I, for one, am very much hoping for that blow. Thank you.
Thank you so much, Anita. That was a really helpful overview of the voluntary work program and how it relates to forced labor and exploitative practices over inmates in immigrant detention centers in the States, starting from 1950. I have a couple of comments that I wonder if you could just elaborate on a little bit. One is something that you alluded to about the policy in the 50s, really relating back to McCarthyism and people being locked up, detained non-citizens because they're deemed too dangerous, and this being something that the Department of Justice actually admitted. So I'm going to try to have you connect that, if you can, to this idea that the United States has never looked critically at our history. And instead of having these sort of moments to reckon with our past and reckon with how our systems may or not be serving folks who live in this country, we're just trying to silence those critiques. And so I want to have you comment on that if you could. And then the second thing that I would love to have you comment a little bit more on, Anita, is that some folks who are subjected to exploitative and forced labor in immigrant detention centers in the States are actually, they claim to be improperly detained because they're seeking asylum, which they have a right to under international law, and they're actually fleeing contexts in which they are facing death in a lot of cases, and it's impossible to stay. So I also wanted to see if you could comment on that connection from fleeing a place of violence to coming to the United States, which under international law really should be giving folks the ability to apply and make their case for asylum. And instead they're being detained and often subject to another human rights abuse, which is forced labor. So I'll pass it back to you, Anita, if you want to comment on either of those.
Great questions. Thank you, Avery. Maybe I'll take the second question first. So when I mentioned the immigration laws, but also the structures changing in the modern times, the past 10, 20 years, I was referring to sort of especially 1996. So under the Clinton administration, 1996 was a real bad year for sort of poor people of color and immigrants. And it expanded the grounds for removability for non-citizens, but also made, in many more instances, including for people seeking asylum, detention mandatory. And so there isn't even discretion in a lot of instances for the judge or the government to release people who are fleeing violence and otherwise coming here irregularly, right? They didn't come on a visa, and so otherwise they're subject to mandatory detention. So the fast forward to 2001, right, with 9/11 and the creation of Department of Homeland Security, the laws were already on the books to sort of really create this mass incarceration system that we have today. I think there's over 52,000 immigrants detained a day now in the United States. And so unfortunately, contrary to international human rights laws and protections, the detention under US law is proper and is justified by that. So that's sort of my comments on your second question. And your first question I can talk about for an hour, and I'm sure other people can talk about forever too, in terms of the lack of us being reckoning with or looking critically at our history. And I'll just bring it back. Not only did we, are we just continuing to profit from a racist, xenophobic reason for the voluntary work program, but we are perpetuating the exploitation of non-citizen and especially undocumented labor in, like, ironically, right? So you have the Braceros program, we have several other guest workers programs, we have obviously, we have actually sometimes trafficking even codified in US immigration law. So like au pairs are seen as, exchange visitors, not workers. And so what the detention labor system is doing is not only banking off of a xenophobic, sort of beginning, but is mirroring what the system does outside of detention walls too, which is mind-blowing to even think about as being okay. But yes, those are my comments, if that's.
Thank you so much, Anita. Lots more to unpack there, but we'll move on for the sake of time to our next speaker, Daniel. Daniel, over to you.
Thanks, Avery, and thanks for having me today. I appreciate the opportunity. I'm Daniel Rosen, Campaigns Manager at Worth Rises. We are a national nonprofit working to dismantle the prison industry and to end the exploitation of those it affects. I focus on policy and legislative campaigns, and I manage the coalition and the campaign to end the exception in the 13th Amendment, which, as it was pointed out, says that neither slavery nor involuntary servitude shall exist within the United States except as a punishment for crime. So I come at this from the perspective of an advocate and also as a formerly incarcerated worker myself. And in Virginia State Prison, where I spent about 5 years incarcerated, I made around $1.50 a day, about $400 a year. Most of the time that I was there in Virginia prior to COVID, I taught GED classes, and I taught about 4 classes a day. The teacher who sat at her desk while I taught the class made about $22 an hour. I did other things there. I tutored students individually. I did maintenance jobs. I trained rescue dogs during my time incarcerated. And $1.50 a day just doesn't really begin to cover anybody's needs in prison. I was lucky that my family was supportive, financially supportive, and I would estimate it probably cost me $4,000 to $5,000 a year, at least, to meet my basic needs inside. So I was getting about 10% of that from my job inside. And that covered phone calls, commissary costs, healthcare copays, clothing, books. I didn't even spend money the way some people did on music, games, and other sort of tablet-based services that are available now. The only contraband I really spent money on was buying fresh fruits and vegetables from the kitchen workers. I want to talk, before I talk about the campaign, I want to talk about some facts just about prison labor itself, just so we can kind of understand the scope of the issue. And I will drop a link later, but the ACLU put out a really good report last year called Captive Labor. And I'll drop a link in the chat to that, which looked at kind of the scope of the entire issue of prison labor. And what they found, just some facts here. There's about 1.2 million people, 1.25 million people in state prison, and about 2/3 of those are working. Their estimate was that the value of all goods and services produced in state prisons was about $11 billion. About $9 billion in services and about $2 billion in goods. According to my organization's estimates, when you look at the issue of stolen wages, that adds up to roughly $14 billion a year, based on if incarcerated people earn minimum wage. Just as far as what labor inside looks like, about 80% of people in prison facilities work just maintenance jobs, facilities maintenance jobs, laundry, kitchen, grounds maintenance. So that's the vast majority of people, just keeping the prisons running. About 8% work for the corrections agencies out in the community, doing things like road crews, grounds maintenance, emergency response, things like that. But that is still for the corrections agency. About 6% work in what's known as state industries or state corporations. As I think Lydia was describing, exists in Louisiana and exists in most every state. Again, about 6.5% are working in that kind of job. 1%, really less than 1%, work in private industry or work for private corporations. And we'll talk a little bit about that too. 7 states don't pay people at all, or at least don't pay people in many jobs. And most of those are really in the South, former slave states, that just don't pay people anything. 3 out of 4 workers report that they work under the threat of punishment, per the ACLU's report, which includes lots of things, but most frequently solitary confinement for refusal to work, but also loss of good time, loss of visits with family, loss of phone calls, loss of access to commissary. There are no sick days, really, even for people who are suffering from chronic illnesses, even for women who are pregnant. There are no labor protections really at all. Courts have said that people incarcerated who are working are not really workers, and they are not protected by standard labor protections that are available to most people outside. There are no OSHA inspectors. Conditions are often unsafe. People work without training. And I think the other thing that Lydia mentioned was important is just that a lot of these jobs do not lead to real opportunities after people are leaving prison. Only a small fraction of people are enrolled in occupational training programs, vocational programs, things that teach them real skills like HVAC or computer coding, things like that. It's a very small percentage. State corrections agencies tend to spend less than 1% of their budgets on paying people. Most spend about 2/3 of their budget paying their staff. And as Lydia mentioned, Louisiana spending about 1% of its budget on rehabilitation programs. That's also pretty typical. 1% is for reentry and rehabilitation programs. It's usually around 1% of the budget. The primary beneficiaries are often state governments. They are really, I mean, the private sector is certainly a beneficiary, but state and local governments are often the beneficiary of prison labor. Just as we were talking about facility jobs, the ACLU report found that those tend to pay anywhere from 13 to 52 cents an hour on average. People incarcerated tend to keep the facilities running in all sorts of ways, not just laundry, cooking, maintenance, but also cutting hair, painting buildings, serving as clerks and librarians and teachers. Pretty much everything that correctional officers don't do. Workers in state industries, on the other hand, like the 6.5% we were talking about, tend to make products or provide services that the departments of corrections sell to other government agencies or nonprofits. They make furniture, license plates, clothing, textiles. They do things, they service jobs like staffing DMV call centers or other types of call centers. Emergency response, 30 states, I think, include incarcerated workers as a labor resource in their, explicitly in their state level emergency operations plans. In California, they fight fires. In other places, they dig graves, they do grounds maintenance at governor's mansions or other state property, state houses. They do asbestos abatement, excuse me. And those state industry jobs tend to pay from about 30 cents an hour to $1.30 an hour. So they're better paying than most of the facilities maintenance jobs, and therefore they're usually more desirable. But better paying is pretty relative here. It's a low bar. Most of the 1% of private workers who do so through the PIECP program, which was regulated, a law passed in 1979, are often garnished. And usually up to 60–70% of those wages can be garnished. I see time is fairly short, so I do want to, as far as prison labor and where it comes from, I think Lydia covered that pretty well. I like to say, you know, slavery was never abolished in 1865. It was moved behind prison walls, and it was moved out of sight. And as she also mentioned, a lot of states' prison populations went from majority white to majority black almost overnight. And after Black Codes, convict leasing, there was a long era of convict leasing in the late 1800s and early 1900s. Around the turn of the century, Alabama, just as an example, was getting 3/4 of its state revenue from convict leasing. And that was not that atypical. Its entire state revenue, 3/4 of which was made from convict leasing. Just to talk about the campaign a little bit, the End the Exception campaign is about 80 national organizations who have come together to pass a constitutional amendment to remove the exception in the 13th Amendment. This has to be a bipartisan effort. Constitutional amendments require 2/3 in the House and the Senate and 3/4 of the states to ratify. So we know that we need a bipartisan effort here. And in a lot of ways, it has been a bipartisan effort. In the House last year, we had almost 200 sponsors, some portion of which were from the Republican side of the aisle. The bill is going to be reintroduced in this Congress in a bipartisan way in both the Senate and the House around Juneteenth. And it is really a very simple bill. It just removes slavery as punishment for a crime. I think one of the issues that we have is a real knowledge gap on this issue. Very few people actually understand that there's an exception in the 13th Amendment. I think people believe that slavery was abolished in 1865. And people who know that there is some exception don't often know what it's for. We understand that this is going to be a long-term effort. This is not going to just take a couple of years. I think this kind of thing is is the kind of thing that can take 5 or 10 years. But we expect and we intend for this to have practical effects and not to be, for sure, there is a moral issue here that says slavery does not belong in the US Constitution, full stop. All people should be protected from slavery. But I think beyond the kind of symbolic aspect of that and moral aspect of that, we do intend for this to have real effects. There will be challenges, legal challenges in state courts once this is passed in various states. And I think, as it was mentioned before, several states have passed state level amendments to their state constitutions because a lot of states have provisions that mirror the 13th Amendment in our federal constitution. So Colorado was the first to do that in 2018. Nebraska and Utah followed in 2020. And then last year, Oregon, Vermont, Tennessee, and Alabama also followed. Of the 5 states last year, Louisiana was the only one where it didn't pass. And, I think just to wrap up, one of the effects that this has, that slavery, and I don't shy away from using the word slavery. Forced labor is also appropriate, but I do think, when you look at kind of what the Supreme Court has said about the quote badges and incidents of slavery, work in prison looks like slavery, not a lot like, it looks like slavery. It meets the sort of definitional tests that the Supreme Court has laid out about that. And that labor, that forced labor, that slavery in prison keeps the price of incarceration artificially low. It makes mass incarceration possible. States are paying people a couple $100s a year that it would normally cost them under kind of normal federal minimum wage conditions, $10,000 or $11,000 a year additionally to incarcerate. So wages is an important part of the issue. Because wages are not just stolen from the people inside, they're stolen from families, they're stolen from communities. People who are breadwinners for their families are not able to do that, and in fact then are a drain on families and communities who are supporting them while they're inside. I want to wrap up with this. The ACLU said it in its very good report, it does not have to be this way. Work in prisons could be truly voluntary. Conditions could be safe. Jobs could provide incarcerated people with real wages and opportunities in vocational training and skills development that meaningfully prepare them for success upon release. Work in prisons could help incarcerated workers build self-esteem and provide a break from the crushing monotony of prison life. And I think that's right. When you work full-time and you still have to rely on your family or others to meet your basic needs, I think there's a real impact on dignity that shouldn't be ignored. This goes beyond some of the other things we've talked about, just the level of human dignity and people's ability to really feel like people while they're inside, but also when they get out. And I'll end with that. Thanks.
Thanks, Daniel. It's just really important to hear both your personal experience having labored in prison and also the important in the exception campaign, both at the state and national level. I just wanted to ask a little bit more about the In the Exception campaign and with the goal of eliminating the exception in the 13th Amendment of the Constitution. One thing I really have learned from you is thinking about how we speak about slavery in the states and not saying we're in a post-slavery environment where there's, forced labor in prisons, but slavery was actually baked into the 13th Amendment, saying it's still going to be okay. And for punishment of a crime outside prisons, it's a different story. So I want to hear from you, Daniel, about what else do you think that we need collectively as a society once we get that exception removed? Do we need admission that slavery never ended, a recognition, as you say, that there's a knowledge gap that there even is this exception? So beyond getting that exception removed, what do we need to collectively reckon with this past and this reality that slavery has never ended?
Yeah, thanks for that. Even recognizing that states and localities are often the beneficiaries of a lot of the labor inside, I think both the public and the private sector, which have massively benefited from free labor and which have benefited just, in a larger way off the carceral sector, should be accountable in real economic terms for the harms that decades of mass incarceration have caused. I think we do have to have accountability mechanisms for this. I mean, our organization, when we have meetings, won't buy Post-its from 3M because 3M sells to prison systems a lot of the heavy machinery that they use in state industries. And so there's some pretty subtle impacts here that I think corporate actors have gotten away with for a very long time and without really suffering any negative effects. I think some of my organization's corporate work is really focused on bringing those, calling those corporate actors to account. We have people who are making billions of dollars through their prison, not just through prison labor, but through their investment in the carceral sector, who are sitting on boards of museums and boards of universities. And I think part of our organization's work is calling that out. There's a demonstration up at the Princeton Theological Seminary today. Michael Fish, who's the head of one of the largest corporations that owns one of the major telecom companies that operates only inside prisons, is the chairman of the board of the Princeton Theological Seminary, an organization that prides itself on its ethics and its morals. And folks are up there today calling him out on that kind of thing. I think that that corporate work is important and that corporate accountability is important for sure.
Thanks, Daniel. We're going to switch gears a little bit to hear from Tatiana, who is going to tell us a little bit about what transitional justice has looked like in other countries around the world, what corporate accountability has looked like in other spaces, and if there's anything that we can learn as in the United States we turn to sort of reckon with our past. So Tatiana, over to you.
Thank you so much, Avery. And first, let me just say that it is an honor to be part of this panel today and to be in such good company. I'm going to start by saying that, as my colleague Avery mentioned, I lead the Transitional Justice and Colombia program at Corporate Accountability Lab. As part of the program, we develop and implement innovative legal and some non-legal strategies to push for the inclusion of economic actors into the Colombian transitional justice agenda, which includes the Colombian Truth Commission and the Special Tribunal. Now, just to clarify, economic actors include companies, multinationals, and individual economic actors, all part of the private sector. The transitional justice mechanisms were a result of years of negotiation between the government and a guerrilla group known as the Fuerzas Armadas Revolucionarias de Colombia, otherwise known as the FARC. And very quickly, just to put a very concrete framework around this conversation. What do I mean by the inclusion of economic actors in the transitional justice agenda? What I mean by that is that companies had a role in armed conflict and mass violence, and as such, as being part of this broad array of actors that were part of the conflict, they are part of the transitional justice mechanisms that is now trying to reckon with the realities of what happened of the past, the present, and the future. For the private sector, that means direct participation in the conflict, financing armed groups, and benefiting financially from the conflict as well. Which I think that for our conversation today, it is very relevant to prioritize this last part of it all, benefiting financially from the conflict is very important. Now, of course, there are some nuances, but to simplify the conversation today, I think that I'll just leave it as that. As part of the program I lead at Corporate Accountability Lab, we also developed a project called the Corporate Liability and Sustainable Peace Lab, known as the CLASP Lab, which later turned into the CLASP Coalition, which is now active and which Avery already talked about at the beginning of this webinar. We invited participants from all over the world, mainly from Latin America and African countries, to share experiences on how the private sector was held accountable or has not been held accountable for their role in atrocities during armed conflict and violence. We wanted to share the experiences and identify replicable strategies while at the same time building a network. So with this experience, or based on this context, we at Cal have been thinking about what the US could potentially learn from transitional justice frameworks in other countries. And yeah, this is indeed a very important question with, unfortunately, some tough realities. Despite hundreds of findings evidencing the role of the private sector in atrocities committed during the conflict and mass violence in Africa and Latin America, transitional justice mechanisms have not been able to effectively address this issue and hold business accountable. This has been an incredibly difficult job, but a necessary part for historical reckoning, I would say, with the harms perpetrated by powerful actors. I wish I had a model that would fit in our conversation that we would seriously advocate for as a replicable model, but unfortunately, I don't think that's the case. Personally, let me also share that before Cal, I worked in the field of forensic anthropology, investigating cases of disappearances and extrajudicial executions. I later worked on the issue of gender and sexual-based violence during armed conflict and mass atrocities, and all within the context of transitional justice. And let me tell you that the biggest challenge I found in my professional path so far is to address corporate complicity in perpetuating injustice and violence. Although this is an incredibly difficult part of transitional justice and historical redress, there are some examples that show how some countries are addressing the role of the private sector, not only for their direct participation in armed conflict, but also for the tactics that businesses use to benefit financially from mass violence. For example, in Brazil, there's currently an investigation against the Volkswagen Group. Yes, the German automaker company, through its Brazilian subsidiary, currently faces accusations of slavery practices and human trafficking during the Brazilian military dictatorships in the 70s and 80s. This is an ongoing case that I think we should be following very closely. But this comes after the company already signed a historic settlement in 2020 with the Brazilian government over the role that Volkswagen, that the company, had during the dictatorship. The company's, in this case, the company's security office collaborated with Brazil's secret police to identify suspected leftist opponents, union leaders, and basically anyone who challenged the brutal dictatorship at the time. These individuals, many of whom were Volkswagen workers, were then detained and tortured, and some disappeared. The company also facilitated the use of their facilities for the purposes of torturing victims of the dictatorship. Now, under the settlement, the 2020 settlement, there is compensation for former company workers and survivors of such atrocities, as well as compensation for the families of the victims. There are also funds for memorials and for studies and collaborations with different universities and institutions to further investigate the role of the private sector in the atrocities committed during the dictatorship. This settlement is considered a landmark settlement in the field. But let me add that as part of Brazil's transitional justice system, the country established a truth commission. This was a years-long process. Although the transitional justice system overall did not really address the role of the private sector in the violence committed by the dictatorship, the truth-seeking and documentation process that was part of the Truth Commission was key in trying to document these issues and preserving some of the evidence. So this 2020 settlement really is the result of the Truth Commission's processes and the findings that were published in the report in 2014. I talked to one of the prosecutors about a year ago of this case, and he just shared the incredibly difficult journey to get to the settlement, but he highlighted the importance of the documentation process and the documentation process through the Truth Commission and the civil society's ongoing efforts to push for investigation and accountability. Now in South Africa, and I do think it's important to talk about South Africa because that is something that is an example that is always relevant to these conversations here in the United States, or you hear about it a lot as some guidance for these conversations. But its Truth Commission was one of the first commissions to include the private sector in its public hearings. They accepted submissions from trade unions, from political parties, from businesses, and they encouraged, for example, financial institutions to also do so. As a result of the investigations and the truth-seeking process, the Truth Commission concluded that, and I quote, "Business was central to the economy that sustained the South African state during the apartheid years." In its recommendations, the Truth Commission proposed ways for businesses, for the private sector to contribute to reparations. This, unfortunately, did not materialize. However, the restorative and truth-seeking processes in South Africa, they have led to other accountability measures, but I think it's important to, again, say that even with guidance from a Truth Commission and with very clear evidence of the role of the private sector in the apartheid era, there has not been real accountability, and companies or the private sector has not contributed to reparations. Now, as I mentioned before, Colombia is the focus of my work. The Colombian transitional justice system, I would say, is the most comprehensive. It was developed with intense participation by Colombian civil society and the international community. It is also based on the experiences of other countries, including the successes and the failures of other transitional justice systems. Now, this is the first transitional justice system that has specific focus areas to address or to attempt to address the role of the private sector in the armed conflict. That is both through its Truth Commission and also its special tribunal, the Special Jurisdiction for Peace. Now, I think we can host an entire panel to talk about this issue in Colombia, current challenges and lessons learned so far. But for the purposes of this panel, I'll say that there has been a key focus on looking at the role of businesses and other economic actors in, I would say, especially anti-union violence and land dispossession, which includes the dispossession of wealth from campesino, Black, and indigenous communities through mass violence. So within this context, I think CAL is learning from and working at the same time with Colombian partner organizations on restorative justice initiatives, where perpetrators that include economic actors and impacted communities, victims, and civil society participate in exchanges and strategies to develop comprehensive reparation plans. These are incredibly challenging initiatives, but in the transitional justice system, I think it's the perfect place to develop such models. Now, I believe that Colombia has been attempting to develop wonderful, replicable, but potentially replicable strategies in terms of guarantees of non-repetition and the overall prevention of mass atrocities. But again, this is a fairly recent system, and we're still waiting to see more outcomes. Now, I wouldn't advocate for the US to follow a transitional justice framework when it comes to the legacy of slavery, racial segregation, or these harms and systems have not ended here in the US, as we all agree here in this panel. But its connections to current injustices such as forced labor in prison and mass incarceration are very clear. Also, I think that the complex composition of the United States, where the legacies of slavery and segregation are addressed in diverse ways, depending on states' policies and political environments, makes it even more challenging. But also, one more thing to add is that the global transitional agenda has come under criticism and sometimes perceived as a westernized agenda imposed in African countries, especially, or as a step-by-step approach that is not context specific, or where the pillars of transitional justice are treated as independent and not as integral components that feed one another. But again, we definitely have an opportunity to learn from transitional justice in other countries and apply some of its lessons here in the United States. They're relevant and useful examples from reparation initiatives and truth-seeking mechanisms that have been explored or implemented to transitional justice, or as a result of transitional justice mechanisms, like the case of Brazil. There are examples that can be part of efforts in the US. I think as we embark in this new era of truth-telling, reparations, and accountability, where the role of the private sector needs to be part of the process of historical reckoning. Specifically, I think that to promote truth, reparation, and justice in the U.S., we should pay particular attention to the reparation initiatives through restorative justice, where a dialogue between victims, impacted communities, survivors, perpetrators are at the head of such initiatives. This has been an incredibly humbling and important lesson to learn on how important it is to be part of these initiatives where these exchanges happen, and in real time you are creating reparation plans and guarantees of non-repetition that truly seek to accomplish the purposes of transitional justice. Again, I think this is a valuable example from the Colombia case. I think we should also look into guarantees of non-repetition and the policies, including institutional reforms, to prevent atrocities that are under development, and perhaps the ones that were created in previous transitional justice systems in Latin America that unfortunately are now perceived as failures. I think there is a lot to learn there, and we should pay particular attention to it. When it comes to truth-seeking and documentation processes, I think there is a lot that we can learn from truth commissions. As we have been seeing in recent years, many of the findings, the documentation and the evidence that has been found through this through truth-seeking processes has been extremely useful, not just for historical reckoning, but also to open judicial cases in different court systems throughout the world. Lastly, I want to say that institutional innovators or allies within institutions that have been able to implement effective and replicable efforts to address the role of the private sector in violence has been a key. Has a fundamental importance in the conversation here, because it is through this institutional innovators that that there has been some positive developments in the field. And I'm borrowing this concept from a wonderful research book by Lee Payne, Gabriel Pereira, and Laura Bermudez, who studied the results from truth commissions and judicial processes throughout the world when it comes to the role of the private sector in armed conflict and violence. And one of their main conclusions was that the role of institutional innovators within these institutions was just key to move things forward. And finally, I think that another lesson is that all positive developments and all the success stories that we have in seeking corporate accountability has been led through a bottom-up approach where civil society and grassroots organizations take the lead and develop the agenda. But I think that based on the number of participants here and the faces that I'm seeing, there is an amazing opportunity to continue the discussion and develop the collaborations. Thank you.
Thank you so much, Tatiana, for bringing in this international transitional justice perspective to the conversation. I think we probably have time just for one follow-up question, although I have so many. And I wondered if you could comment on what is often seen as one of the pillars of transitional justice, which you've mentioned throughout your intervention, which is guarantees of non-repetition. And I want to think about how it applies in the US context, or how we've totally ignored that pillar of transitional justice in our context, where we have, our history of where the US economy and much of our infrastructure was built on slavery. And today we have slavery in prison. So if you could comment on just how that pillar is absent in the US and perhaps what we have to learn from that, I'd love to hear your thoughts.
Absolutely. Yes. I think that this is a pillar that has been developing, and I'm conflicted about using the word pillar, because I think that where a lot of criticism for the transitional justice framework has come about, just seeing things as different pillars instead of as integral areas of the field that contribute to each others. But let's say that for the purposes here, public policy has been part of the conversation on guarantees of non-repetition, and also institutional reform that has been a missing piece, but yet that has so much power and should be a fundamental part of the conversation. I see this in the case of Colombia, where as you're talking about reparations, you're talking, for example, about, well, we need a memorial, or this is the kind of conversation that we need to have, of the type of workshop that communities, that a union wants to see happening. And as part of that, what we want to talk about is a potential educational curriculum to talk about anti-union violence. And that's when we start getting into guarantees of non-repetition as a key component of not just its own individual pillar, but also as reparation and as something that communities need, communities are focusing on. Impacted groups and families of victims are extremely invested on. Now, I think that here in the U.S., it's something that that it's happening in some contexts. I actually this morning I just attended the reparations committee meeting from the Evanston city here in Illinois, where there is a very strong focus on 3 areas of harm that then lead to 3 specific working groups. One is on economic development, the other one is on housing and zoning issues, and the third one is on education. That is part of wearing guarantees of non-repetition. If we were to try to have some sort of like a comparative or analogous conversation with transitional justice systems abroad, but I think that pillar, as you said, has been a missing piece. But fortunately, what I am seeing is a bigger focus on it, and something that hopefully we can replicate here in the US. But again, as I mentioned, I am seeing that happening here, and I think that that is just a fundamental piece.
Thank you, Tatiana. I just want to note for everyone that we have opened the chat. So if you didn't get a chance to put in any of your questions while our panelists were speaking, you can do so now, and we'll get to them in just a second. In the meantime, I just want to really thank all of our incredible panelists for being here today, to Lydia for walking us through plantation prisons in Louisiana, focusing on Angola and the horrendous conditions there within a historical context. I want to thank Anita for walking us through the voluntary work program, its origins from the 1950s and before, all the way to today, and efforts for corporate accountability within the private detention facility space for immigrants. I want to thank Daniel so much for talking to us about his own experience laboring in prison, and for talking to us about the End the Exception campaign, both in the States and nationally. And we really look forward to seeing the impacts of that campaign that are already flowing. And to Tatiana for walking us through some examples of transitional justice around the world and giving us some thoughts about what the US could learn. So now I'm going to turn to some questions. Again, the chat is open if folks want to add, but I will start with the couple that we have now. The first is directed to Lydia. Someone is asking about Angola prison has tours that are open to the public. If you know what image these tours try to present to folks who come to see the prison. Lydia, I'll give that question to you, and then we'll move to the next.
Yeah, there was recently a glossy insert in the Sunday New York Times from a cruise line advertising cruises, voyages along the Mississippi River, and a day trip to the Angola penal plantation, where for some amount of money, tourists could get on a chartered air-conditioned bus and drive through Angola, the prison, as a tourist stop. We have clients who have been working in the fields when tourists have pulled over in their bus to take pictures of our clients as they are being forced to, to hand pick turnips. It's just, there's no words. I'm speechless at this concept. At the same time, Angola does not permit reporters to enter the premises. There's not open tours of Angola, generally speaking, but somebody is making money off of this relationship with the cruise line. At Angola, there's a museum that's run that documents the history of the place. There's The freemen, the officers, and their families live on the plantation grounds. There's swimming pools and golf courses that are built by incarcerated labor. There's schools. There's grocery stores. There are free people who live on the grounds, and then there are tourists who come and tour it. And I have nothing to say about that except that it's just yet another symptom or sign of how deeply broken the system is.
Thanks, Lydia. And I just got a message from Anita, who sadly had to leave to go teach a class. But if folks want to reach out to her, we've been given permission to share her email, so we'll do so in the chat momentarily. But I'll continue for now with the questions. So I guess one question that I had for Lydia and Daniel that I think both of you spoke to a little bit about, but I'd love to hear more in terms of concrete ideas for what could be done, is if we're, and I assume many of us are looking to abolition as the end goal, but in the meantime, what could prison labor look like? What would a non-exploitative or less exploitative system look like in the US? Lydia, I know you mentioned a couple of things, and Daniel as well, but I wondered if you all could elaborate on that, thinking about particularly in the short to medium term. So I'll turn it maybe to Daniel and then Lydia.
Yeah, thanks. I think that's a great question. I think Lydia earlier laid out some conditions for what they thought prison labor ought to look like: voluntary, safe, compensated, and building up people for success in the future. And I think that's right. I think as the campaign moves forward, as states, and states are important here, I think states are really leading the way. There are 5 additional states who are, actually 7, working on the state level bills in 2023 and 24. I won't go through all those, but I think as challenges move through state courts, I do think hopefully we will start to see prison systems that at least do away with some of the worst aspects of forced labor. And to me, I think some of the low-hanging fruit has to do with punishment, and removing punishments for refusals to work. I think when work becomes voluntary in prisons, that is kind of the fundamental condition that needs to be met. I think pay is absolutely important. Safety is absolutely important. But I think to the extent that prison labor can set people up for success, labor that's focused on keeping facilities running, often I think at the expense of vocational programs or educational programs, is also, I think, some of the low-hanging fruit. The fact is, people, 95% of people are leaving. And the ones who are leaving without jobs are the ones most likely to come back. So I think we have a lot of work to do on vocational programs, but also on education. I think the people that want to be in education programs, people are often told that they cannot be in education programs, that they have to be working instead. And that is abhorrent, for sure. I'll leave it there, given time.
Lydia, do you want to jump in here?
I would just echo everything that Daniel said. The only thing I might add is that if there was a focus on opportunities to create opportunities for folks to get certifications for jobs that they can hold outside when they come home, in California, incarcerated people are sent to work to combat wildfires, but they can't become firefighters when they come home. Because there's a prohibition on folks with a record doing the job. Same in Louisiana for being a barber or being a welder. There's all kinds of certifications that folks can't qualify to get, even if they gain those skills. And so really focusing on as to Daniel's point, really focusing on giving folks jobs that they're going to take with them and skills that they're going to take with them when they go home, I think, is a really important piece of this.
Thanks, Lydia. We are just at time for our panel. I would love to ask one more question to all of the panelists. I just wanted to check that you all can stay on for another couple of minutes. Great. So I thought to wrap us up, we could end with thinking about what might our society and the states look like if we do the hard work of reckoning with the past, of our history, of closing plantation prisons, of ending the exception to the 13th Amendment, of thinking about these interrelated pillars or pieces of transitional justice. How would things change? What would our country look like? I'll just leave it there. And if anyone wants to jump in with some thoughts, I'd love to hear them. All right, without anyone jumping in, I am going to cold call you guys just for, you don't have to tell me, the whole vision of what the world would look like, but I'm thinking of a world in which obviously all people, including people of color, especially African Americans, have autonomy over their own bodies and can decide if, when, and how they decide to work and for whom, under what conditions. I'm thinking about a world where we're not afraid to be held accountable, whether we're in government or individual people, or we're part of a company that has done harm in the past, and actually looking hard at that past and changing for the future. Tatiana, I'm going to put you on the spot for any thoughts you have about what the states could look like, and then we'll pass it to Lydia and then to Daniel.
Yeah, absolutely. I was just thinking about the importance of collaborations, but really starting from the bottom up and having these conversations with grassroots organizations and civil society in general. I think that it would be fascinating to just start from there. We see so many initiatives going on in the U.S., and I think that would be the first the first step is to perhaps have these conversations and go into some sort of I don't want to get too technical here, but comparative analysis of what are they doing in the U.S. Now, my area of expertise is abroad, and yeah, I think I definitely want to echo what you just said, not being afraid of being held accountable. But I think that now in more of a global supply chain kind of language is just education and just awareness, right, of these are the harms that have occurred. I think that a lot of people, and I see this trying to talk about my work, are not aware that we are benefiting from the systems as consumers, as just being part of this type of conversations. People are completely unaware that this is going on. So I think that raising awareness, talking about these issues, and having the difficult conversations is part of the first step of this ideal world. But beyond that, I don't know if I have a more concrete answer to your question.
I think that's fair. And I'll have to admit, I'm pushing myself to also think past what if we can get through, all of the horrors that are in front of us. Lydia, do you have any comments?
Yeah, that is a very difficult question to answer, but one that's worth thinking about for sure. I think that if we ended plantation prisons, and if we reformed the way that prison labor and labor in the immigration detention center context is structured now, we'll be safer. We will all be safer. Communities will be safer. Families will be safer. Incarcerated people will be safer. And there will be more opportunities for people to be productive and have healthier, productive, prosperous lives. And I'll just leave it there.
Thanks, Lydia. Daniel?
Yeah, just to kind of echo a couple things that were said. I think we have to grapple with the reality that people don't want to see. Slavery is still legal. Slavery was never ended in America. There's an unbroken chain, especially, and Angola is just such a perfect representation. There's just an unbroken chain of slavery that has never ended. And I think we have to really wrestle with that. I think in a different kind of world, and a world where I guess prisons still exist, we have to start giving people agency. We have to start putting people back out into the world who have experienced a sense of agency and authorship even while they were in prison, if we expect them to succeed. I think there are plenty of people with financial interests in people not succeeding. That's a problem. But you know, a lot of tough on crime rhetoric is, as they say, it's cheap politics, but it's expensive policy. You know, I'm disheartened to see a little bit of resurrection of some of those things that looked like they were on the downswing a couple of years ago. But I think when it comes back to the level of the individual and people's relationship with work, we have to give people a sense that that they have value, that they have dignity, that their work has dignity, and not to be laboring under the color of slavery anymore.
Thanks, everyone. And I just want to thank you again for being part of this discussion today, connecting some seemingly disparate concepts and moving the conversations forward. Thank you for being with us. Lisa, I'll pass it to you to close us out.
Great. Thank you, Avery, for such a wonderful facilitation of such an important conversation. And thank you to Lydia, Daniel, Tatiana, and Anita for your contributions of this topic, which hopefully more will have an opportunity to view and to raise awareness of this issue, and also how it relates to the ongoing efforts of the country to reckon with its legacy of slavery and other episodes of enforced labor. I want to remind everyone that this is an ongoing series. It is usually scheduled on the academic calendar. So the next panel to be announced will be in the fall. And so please do keep an eye out for that, for the Transitional Justice in the USA series. And if you are interested in joining our listserv, please write to me directly and I'd be happy to add you. Thank you, everyone. And for the conversation to be continued, definitely. Have a good rest of your day.